Emmanuel A. Cup. Calling case 2355852, people of the state of Michigan versus Emmanuel A. Cup. Defendants charged with count 1, larceny, weapons, firearms. Count 2, weapons, firearms, possession by felon. Count 3, felony firearm. Count 4, felony firearm. Defendant has an habitual offender fourth offense notice. Appearances for the record, please.
Good morning, Your Honor. Daniela Parrish on behalf of the people, CR438.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles on behalf of my client, Mr. Acuff, who is physically not present in your courtroom, and I would ask the court to waive his appearance both physically and virtually, because I do not believe he appears virtually. He is in the Wayne County Jail.
Court will waive the defendant's presence. What's your pleasure?
We have discovery, Your Honor. We want to set it for an in-court preliminary examination.
All right, the court will continue to plead not guilty and set this matter for preliminary exam. The exam date will be
April 13th at 11 a.m.
April 13th at 11 o'clock.
Okay. Can I have a minute, Your Honor, to look at my calendar? I'm sorry about the phone. You said April 13th.
April 13th at 11 o'clock.
I am scheduled to start a trial. I do not think it's going to go. So I will take that. I will take that.
Okay, April 13th, 11 o'clock, bond will be continued.
Okay.
Good morning, Ms. Spahn.
Good morning, Your Honor.
What can I do for you?
I have Howard Winston today.
Okay. Did you file an appearance?
I'm appointed, Your Honor.
Calling case 2258781, people of the state of Michigan versus Howard Winston. Defendant is charged in count 1, receiving and concealing stolen property, motor vehicle. Appearances for the record, please.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And Janet Span, P43281, appearing on behalf of Howard Winston.
What's your question, Ms. Spahn?
Your Honor, today's the date and time for a competency hearing. He has gone to the forensic center, found to be incompetent, and they do not believe that he could be restored to competence based upon his cognitive abilities. I would ask that this matter be dismissed.
Speaker?
Your Honor, I do not have that report. If defense counsel could indicate to me at what date he was found incompetent, and
The report is dated March 3rd, 2023.
our office does not dismiss if he is found incompetent. I could not, again, have the report in front of me, but normally the report will indicate a certain amount of time. We're going to go into a treatment to see if he can be rehabilitated in order to become competent.
That's
Within
true, but in
15
this
months.
instance, they indicate that due to his significant impairment in reading abilities, his limited capacities for learning, it's their opinion that the way the available information suggests he is unlikely to attain competence.
Your Honor, you do not mind if the clerk provide me a copy with that, but the people
You
still
can take a
will.
look at it.
Thank you, Your Honor. Thank you.
They're saying that he's not going to regain competency. It doesn't make a whole lot of sense to keep him in the county jail or refer him to treatment. It's going to be fruitless.
I understand, Your Honor, what you are saying. Unfortunately, it's our unit's policy. I do not have authority to dismiss it. I only have the ability to ask for a follow-up hearing within 3 months.
I understand that with your dismissal usually follows some commitment to a site facility.
I understand. I'm unfortunately unable to do that within the 15-month period. We just had a training in our unit 2 weeks ago. We were specifically instructed that we are not to dismiss cases within that 15 window. So obviously, Your Honor, you're the judge. However, you determined to proceed. The people are unable to dismiss at this time.
Don't you normally pursue some kind of civil commitment?
We do after the 15-month period, and the defendant has had an opportunity.
That makes absolutely no sense whatsoever. They're saying that the defendant is not going to regain confidence. We'll have to wait 15 months for.
I understand, Your Honor. I understand. But unfortunately, my hands are tied. I have to reach out to a supervisor. I
I
cannot.
think that may be a better course of action. Reach out to a supervisor.
Exactly.
Put this up for 1 week so that you can get that done. You guys can determine what it is that you want.
Thank you, Your Honor.
So actually, I'm gonna do a little better this week because we're closed on Thursday and Friday of next week. So I'll put it over to April 10th at 8:30.
April 10th, Your Honor.
Yes.
Thank you.
April 10th at 8:30?
Yes.
Okay. Ms. Perrick, I thought you had a copy of the report. I initially got it from the court, and I know the Forensic Center mailed you one. Okay, thank you.
Thank you, defense counsel. The judge has provided me with a copy, so I do have it for my supervisor, and I'll have some answers for you on April 10th.
Okay, April 10th, Mr. Winston, okay?
Say, okay.
Zoom back on April 10th at 8:30.
All right.
Okay. Thank you. Good day, everybody.
Thank you.
Okay.
Your Honor, is this your only copy or may I?
That's her.
Only copy? Madam Clerk, would you mind to make a copy for me? Thank you so much.
What's your name, sir?
Emmanuel Acuff.
Mr. Acuff, we just did your case. We put it over to
April 13th
April 13th
at 11.
at 11 o'clock for preliminary exam. You're all set, sir.
I'm sorry.
You're all set.
All right, thank you.
Thank you.
Yeah.
Ms. Hamilton, are you ready?
Yes, I need to pull over, but otherwise.
I can't hear you.
Yes, I just need to pull over.
That's a good idea. Calling case 2356054, people of the state of Michigan versus Kevin Smith. Defendant is charged in count 1, unlawful driving away motor vehicle. Appearances for the record, please.
Good morning, I'm Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Vanessa Hamilton, P8107, on behalf of Mr. He's down as Kevin Smith, but I've been informed his name is actually Keith Smith Jr.
What's your pleasure, counsel?
Yes, Your Honor, I believe I'm in need of digital discovery in this case still. Otherwise, we'd like to set it for a preliminary exam date if possible.
Court will continue the plea of not guilty and set this matter for preliminary examination on
April 13th at 9:30, Your Honor.
April 13th at 9:30. Is that a good date and time?
Give me 1 second, I believe it is. Yes, that's fine.
April 13th at 9:30, bond will be continued.
Thank you.
Honor, if I'm just convey to defense counsel, the people do not have any digital at this time, but I went ahead and reached out to the OLC to inquire if they do have any. This was done 2 days ago. I have not received a reply nor any additional digital. If you believe that there should be, please reach out to me directly by next Monday, and I will continue to try to reach out to the OIC and get it resolved for you, okay?
Okay, thank you.
Thank you.
Ray Richards. I have anybody here for the exam at 9?
Yes, Your Honor.
Come on in. Guys have me till 10.
Okay.
First time signs. assault with a dangerous weapon. Count 2, felony firearms. Appearances for the record.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. For the record, Terry Johnson, P70773 on behalf of Mr. Jabari, who's present and stands to my right. Your Honor, date and time set for exam, and we are ready to proceed.
Tell me your name, sir.
Aliyah, very John.
Are you ready to proceed?
Yes, they are, Your
How many witnesses?
Honor. Most likely just one witness.
Ready to call your witness?
Yes, at this time, the people call Officer Christopher Young.
Yeah. Morning, sir. Please step forward, give your name and spell it to the court reporter.
Yes, sir. Christopher Young.
You raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in the spot. Keep your voice up nice and loud and speak to that microphone. Okay?
Yes, sir.
Okay, begin when you're ready.
Good morning. Could you please restate your name for the record?
Christopher Young.
And I want to take you back to the date of March 2nd, 2023. Do you remember that day?
Yes.
Were you at or near the location of I-94 highway near Livernois?
Yes.
Then in the city of Detroit, county of Wayne?
Yes.
And are you currently employed?
Yes.
In what capacity?
Detroit Police Department Special Operations Unit
And how long have you been employed as a police officer?
since 2018.
And on that date, were you on or off duty?
I was off duty.
And did something happen that brings you into court today?
Yes, I was traveling westbound coming from downtown. I actually think I was coming from turning the port slip. And I was getting ready to merge into the left lane. And the vehicle behind me was merging at the same time. I merged, he ended up going in the center lane, passing me, turned, came to the side of me, looked at me, got in front of me, slammed on the brakes, and then pointed the gun.
And could you describe the type of vehicle?
It was a white Volkswagen SUV.
And you said that you and this vehicle were trying to merge at the same time?
Yes, we're trying to get into the left lane, the fast lane at the same time.
And you also stated that this, a gun was pointed at you.
Yes,
Where was the vehicle, when this happened?
it was directly in front of me.
And could you see the driver of that vehicle?
Yes, I saw the driver when he passed.
Is the driver in the courtroom today?
Yes, he's right there.
Could you please point out that individual and identify an article of clothing that they are wearing?
I'm a blue face mask with a black one next to the counselor.
Your Honor, let the record reflect the identification of the defendant.
No objections for exam purposes only, Your Honor.
And you said you were able to see the driver when he was alongside you.
Yes, because he slowed down.
Did you notice anything about the driver at this point?
Did I notice anything?
Yes.
No, I just noticed his face.
And when he pulled in front of you, can you describe what happened?
He pulled in front of me, slammed on the brakes, and turned around and pointed a firearm at me.
And was this in his left or right arm?
His right arm.
And could you describe that firearm?
It was a black handgun.
And was there anything else? You can see this handgun through the rear window of the vehicle
Yes,
and through your front window.
yes.
Is there anything obstructing the rear window of the vehicle in front of you?
No.
Is there anything obstructing your own?
No.
And how close were you to the vehicle?
I said we were about 5 feet apart.
And how many times did the driver point the gun?
Just one.
And how did you feel in this moment?
I'm upset.
Were you afraid that he would shoot you?
Objection leading, sorry, objection leading.
Were you afraid?
Objection again leading, Your Honor.
So when you said that you were upset, can you describe further?
I'm just, as a normal person, was going to someone pointed a firearm.
Did you feel any other emotions at this time?
No,
And what did you do after the weapon was pointed at you?
the vehicle sped off the freeway and I followed behind it with a license plate.
And were you able to obtain a license plate?
No.
And how long did you follow this vehicle?
I would say about a good mile and a half.
And did you do anything else after following this vehicle?
I called MSP and Detroit Police Department.
I have no further questions.
Cross-examine.
Yes, thank you, Your Honor. Good morning, officer, correct?
Counselor.
Okay, good morning, how are you? Okay, a few questions here, just want to make sure I understand. You've been I noticed today you're not wearing glasses. Do you wear glasses at all?
No.
Okay, what was the weather like that day?
It was a gloomy day.
Gloomy? Okay, sun wasn't out, correct?
I don't know.
Not a problem. And just so I understand, you and the person you identified as my client were trying to merge into the left lane, correct?
Yeah.
Okay. And what was this on a freeway?
Yes, I-94 westbound.
Thank you. Okay. Now you said that, you weren't able to get the license plate?
No.
Okay. This car was in front of you, correct?
Right,
Is that correct?
that's correct.
Okay. And according to your testimony, you said 5 feet, correct?
Yes,
Okay, now just so I'm clear, when you say 5 feet, is that from where you are in the driver's seat to the rear of this vehicle?
I would say yes. Maybe from where I am to where you are.
What, do you remember what kind of vehicle this was?
Yeah, it's close like
Remember what color it was?
white.
Remember the type of plate it had on it?
It was out of state, that's all.
May I approach, Your Honor?
May.
Thank you. Your Honor, I'm handing, the witness what's been marked as defense exhibit 1. I believe it's been stipulated to, is that correct, Counselor?
That's correct.
Okay. Does that represent the vehicle that you were looking at on that day?
Yes,
Okay. Does it accurately represent?
yes.
Okay. I'm looking at that vehicle, do you see anything on the back window that's different from what you saw that day?
Besides being in the garage and the lighting being different, no.
Okay. But that, you would agree with me in looking at that picture that that has a dark tint on it, correct?
Yes,
Okay. And is it your testimony that on a gloomy day on March 2nd, 2023, that you were able to see someone pointing something at you?
yes,
Let me finish. Through a dark tinted window?
yes, because it's factory tint today. This is
How-
inside of the building.
Hold on. How do you know it's factory tint? Did you get close enough to examine that tint?
If I was 5 feet away, I'd say that's pretty close.
It's not my question. Are you a tint expert?
No,
Okay, so you don't know what kind of tint it was, correct?
no,
Okay. And you were able to, through this dark tint, ascertain that this person not only pointed a firearm at you, but you even identified the color of the firearm, correct?
yes,
Okay, through this dark tint.
yes.
Okay. One more moment. And this object that you state is a firearm that was pointed at you, how long was it pointed at you?
I'll say maybe a couple seconds, maybe 1 second. It was like a point and then put it down.
Point and put it down, and while this was going on, were there other cars around?
I wasn't focused on any other cars.
I'm sorry,
I
sir?
wasn't focused on any other cars.
Okay, but do you know if any cars were around you? Were you the only two on the freeway?
Pretty sure we weren't.
Okay, and you said you said that Mr. Jabari turned around. What did his car do? Was his car continuing to go straight when he had turned around?
Yes.
I have no further questions at this point.
Can you redirect? Okay, sir, was there anyone else in the vehicle with you at the time? Was there anyone else in the vehicle with the defendant at the time?
No, sir.
How long have you been a police officer?
Since 2018, sir.
2018?
Yes, sir.
What's your assignment?
Right now, we're in special operations, probably unit downtown.
So I take it you've seen weapons before?
My job.
All right, you know when you see one?
Yes.
And you saw one on this day?
Yes.
Any questions based on my questions?
You saw one, just so I'm clear, Judge King asked you if you saw a weapon that day, and you said you were able to see it through the tent, correct?
Yes.
Okay. No further questions, Your Honor.
Are you moving for the admission of the exhibit?
Yes, Your Honor, I'm sorry.
No objection?
No objection.
Public? Thank you, sir. You may step in, sir. Yeah,
Thank you.
on behalf of the people.
Not at this time.
No, Your Honor, thank you.
Your Honor, at this time it was moved to bind over, the people moved to bind over on all counts, those would be count 1, assault with a dangerous weapon, and count 2, weapons felony firearm. As we heard from the witness, he has several years of experience as a police officer. He knows a gun when he sees one. On this day and time, he saw a vehicle get into the lane and they tried to merge at the same time. This vehicle then pulled in front of him. He said he was able to see the driver when he pulled alongside him. And then he was able to clearly see through the window with no obstructions both on his own front windshield and the rear windshield of the vehicle in front of him. He stated he saw a black handgun pointed at him by the driver of this vehicle in front of him, the white Volkswagen. He felt upset, as he said any person would, having a gun pointed at him. He then followed this vehicle for 1.5 miles before calling.
Objection, I don't believe that was part of the testimony that he followed for 1.5 miles, but it was my mistake, Your Honor, thank you.
Before losing sight of it and calling Michigan State Police. People believe they had met the burden of probable cause and moved fine over to the third.
Thank you, Your Honor. Here, and I'll be brief. A couple of things. Number one, on this gloomy day that was described by the witness, the complainant, with factory tent, I don't believe that he was able to eat, and I don't know what kind of tent it was. He mentioned factory tent. He did state he's not a tent expert. We don't know for sure exactly what was pointed at him, if anything. To describe a black gun through a dark tinted window, I think, again, I have a slight issue with that. I think that'll be an issue of credibility. But however, there are two other things that I don't believe the people met. Number one, officer never said he was in fear. He said he was upset. As this court is aware, there is a difference between being upset and being in fear.
And as you are aware, for felonious assault, the standard is putting a reasonable person in fear or apprehension, even if he was not himself in fear. If pointing a gun at someone would put a reasonable person in fear or apprehension of battery.
I completely understand, Your Honor, and again, I guess the question would go back to, as this court has pointed out in its questioning, he is an officer but again, I would state that, but the other part, Your Honor, I did not hear that this happened in the city of Detroit.
Yes, it did. He gave the location. He said, the prosecutor asked him, was that in the city of Detroit, county of Wayne? He said, yes.
Okay, if that was stated, then I stand corrected, Your Honor, but I just asked that based upon, I do understand this is a low burden here. I completely understand that, but just making a record that his vision could not have been, his vision had to be obstructed with that test here. For that reason, I asked that this court deny the bind over. Thank you, Your Honor.
So the defense exhibit here, I guess this is exhibit A.
Yeah, 8 or 1, whatever the court marks. Yes, Your Honor.
According to this officer, would not be a fair and accurate representation as to what he saw on that day. As he said, the lighting here in this garage is different than what he saw out on the street. Nonetheless, he stands in a different position than you or I or any other ordinary individual, given that he is a trained officer who has seen guns on a number of occasions, who's able to identify people presumably, and was able to do so according to him here. I haven't heard anything that would suggest this would be a question of fact to be determined by a trier of fact. That being stated, the court is satisfied with people with their verdict of probable cause as it relates to the charges contained in the complaint. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be April 14th, 2023 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor. You and your staff have a good day, and always a pleasure to see you.
Your Honor, if I may, Daniela Pierce on behalf of people who see 5495. And I apologize, I know the ruling is 40. I'd like to bring something to the court's attention while I was outside on a different case. Officers that are at the same precinct as this Detroit police officer have indicated that the defendant has been going to the precinct, taking pictures and whatnot. I would like to, I don't know if there's a no contact, but I would like to reiterate to the defendant to not be going to this complainant's place of work. It would be a violation if he has a no contact. I'm not aware, but if he does not have a no contact order with this, I would ask that the court implement a no contact order, or if he does have one, reiterate to him what that means, so that this behavior can stop.
Unless he's absolutely out of his mind, I don't think he would be trying to intimidate the police officer.
This is what the police officers assumed. I cannot tell you what is going on in his mind. I can only tell you the actions that they witnessed him do.
Your Honor, again, it's, I will, which I do not believe that is the case, but I will have a conversation with my client. My client and I have been in constant contact. He has not tried to do anything on his own, to my knowledge, where he has tried to assist me in taking pictures or going places. I mean, I would agree with the court. It would be completely out of his mind, and I will submit him for a psyche valve if that were the case. So just one of the places on the record.
Sir, you understand that you are serving no good purpose in going to the police station and doing what may be considered or perceived as a threat to police officers.
Yes, Your Honor, I'm going there.
I'm sure you watch the news just like the rest of us, right? Probably not a good idea to try to intimidate a police officer in any form of action, right? You're not crazy, are you? Because if you're crazy, we can address that.
No, Your Honor, I'm not crazy. I went for my.
Thank you. Thank you, Your Honor. Are we free to leave, Your Honor?
Yes, sir. You're
Thank you, Your Honor.
Thank you, Your Honor.
Approaching a separate matter, Your Honor. Sure.
What's up? Gary, what's up?
Trying, I'm trying. They heard about Gary out there.
Yes, yes, I think. Shocking. Just see Gary Thursday, Friday. Thursday, I see. Russia, trying to get some.
Yeah,
No, I know.
Friday,
I realize
here.
that.
Yes. And I know
yeah. And I saw him 2 weeks ago in Macomb County. I was in trial. But apparently the funeral's next Saturday.
So is it? I'm glad you told me, that's the first I heard.
Out in Garden City. What's that?
Where'd you get the information?
His cousin, who's the pastor, who's gonna be doing it.
Oh, okay.
It's Inkster Road between Ford and Cherry Hill. I think it's Faith International Ministries.
Perfect.
I can get it for you.
Shit, Saturday.
Not this Saturday, a week, the 8th. That's what I was given.
Right.
Yes. It is Christian Faith Ministries, 27500 Marquette. Marquette, Garden City, 48135.
Thank you so much.
All right. Good to see you.
Good to see you too.
Take care.
Appreciate you. Have a good
Bye-bye.
day. Want your exhibit back?
1 second.
Y'all don't mess with shorty.
Please quiet down. Thank you, sir.
Just 1 second, Mr. Just have a seat back up straight. No, Your Honor, Judge Bryant often requests a pre-sentence investigation report before sentencing.
Oh, pre-sentence investigation, I'm sorry. You said probation. Yes, absolutely. So I'll fill out a slip and I'll submit a request for that, Judge King.
Okay, so they're gonna need his contact.
Okay, yes, Judge.
So I'll provide Mr. Pointer's address and telephone number so that probation can contact him.
Thank you, sir.
Okay, thank you. All right. Mr. Pointer, we're gonna come back here May 3rd. If you want to proceed, I'll be right out and I'll chat with you, okay? All right. Yep, I'll see you in the hall, okay? 1 second.
She said only on drunk driving and police officers. So that's something she wanted. I'm sorry, I was like.
So I don't deal with her. I usually
Yeah.
Good morning, Madam Prosecutor. Do you know if the attorney will be signing on for this case?
Gentlemen,
He
gentlemen,
asked me
gentlemen.
to text him, so I'll text him when you are ready for me.
Okay, I've given the file to Judge King. He's looking over it, so you should text him, ma'am.
Okay, thank you.
Okay, thank you. date set as what I have, so I have to specify that. It's not that in June. That would be my year. And we'll give her a June return date.
All right, Christopher Moore, calling case 2159420, State of Michigan versus Christopher Moore. Defendant is charged with count 1 assault, intent to do great bodily harm, less than murder, or by strangulation. Count 2 weapons, firearms, possession by felon. Count 3 carrying concealed weapon. Count 4 and 5 felony firearm. Defendant has a habitual offender second degree. Appearances for the record.
Good morning, Your Honor. Lauren Yersessian on behalf of the people, P67104.
Judge, could you just pass this for 30 seconds? I'm on the record with Judge Thomas and Frank Murphy.
Okay, let me know when you're ready.
Sorry, thank you.
One of your term probation, substance abuse screening, testing, and treatment directly, anger management, and or matters counseling as directed and if directed. In addition, any terms, conditions,
Would you like for the offer to remain available?
Sure it is, although Mr. Buckingham has indicated that he's not going to accept any of these, he might change his mind.
That's around 9:30. I was gonna do this, these guys come up.
Mr. Shaw, good morning. Is Mr. Gooden here?
I'm sorry?
Is your client here, your 10 o'clock client?
No, not yet.
Not yet. Okay, Mr. Fox is here.
Okay.
Check. One of the good known cases.
You know how to get this back?
This one. I'm not sure. I have to go check. Okay.
Yeah. Judge, I apologize. This is Magidson. I'm back now.
All right, we're back on the record on People versus Christopher Moore.
This one, no, there's a.
What's going on, guys?
Check.
Good morning, Judge. This defendant has two matters under two different names. He has a 2001 matter under the name of Christopher Moore and a current matter under the name of Christopher Harris. The people are asking for an adjournment as to both cases at a one-week adjournment. There are issues with both. I will start with the Christopher Moore matter, Judge. This case is an older case. The defendant actually failed to appear at a exam in 2021. Since then, it was brought to my attention this week that the OIC is no longer the OIC, and one of my key witnesses has moved out of the state, which is requiring me to arrange for the transportation for that witness and locate a new OIC. Also, one of my key witnesses, Detective Mohammed Barakat, is on furlough until this Sunday. So I have multiple issues with that matter. Then I have the 2023 matter where my officer in charge informed me that he has tested positive for COVID. This is a necessary witness also, and I was informed that multiple other witnesses, officer witnesses, also are on furlough. So I'm asking for a one-week adjournment.
Mr. Magidson?
Judge, I oppose these adjournments. We had a PCC hearing last week, and issues of
2023 matter first. You don't think the officer having COVID is good cause for an adjournment?
The officer is not the complaining witness. The complaining witness is the only person that's going to testify. And so
the people's case, is this a necessary witness?
Yes, Your Honor. I would have been calling the officer in charge. There is an interrogation. There are multiple. This is not a matter that I would just call one witness for.
The interrogation, there was no confession. There was an interrogation, but it was all right. No, I oppose that. My client is locked up, and I oppose that adjournment.
Well, hold on a second. So my original question to you is, you don't think that that's good cause that the officer has COVID?
No, because I don't believe the officer is a necessary witness.
Well, she does, and she says she's called.
Well, then we're gonna see if he testifies. We'll find out.
All right. So the court finds good cause for that adjournment. What's the other case?
That's his Christopher.
Okay, so in that case, Mr. Magidson, your client created his own peril in that he caped you some time ago, and now, presumably at the time that he caped you, people were ready to go with their case, but he didn't show up.
Okay.
All right, so sounds like it's settled. I'll adjourn both matters for 1 week.
Well, what about the other matter, Judge? Just because one gets postponed doesn't mean there's good cause for the other one.
I thought that's what I was just discussing. Your client created his own situation by not showing up in the first place, didn't he?
Well, that's on the Christopher Moore case. He showed up on the Christopher Harris case.
Okay, all these.
He was
different names.
arrested on the Christopher Harris case. That was the only reason why he was arraigned on the case he was habeas from.
I'm
Okay, maybe
confused.
it's about backwards. Which one did you habeas on?
Christopher Moore, Your Honor. And
that
the
the one-
witnesses were present at that exam. I have spoken to the witness who's now moved out of state. He indicated to me he was present at that date and ready to testify.
Okay. So I find good cause to adjourn that matter. The other
Right.
case, I thought was the one where your officer in charge has COVID.
That's correct, Your Honor.
Find good cause in that one as well.
Okay. So when is this going to be heard?
You asked for a 1 week adjournment, right, Ms. Marcesian?
I did, Your Honor. I do realize, though, I believe the court is closed on the 6th and
It's
7th.
closed on the 6th. What's our next available date? How's April 10th at 11:30?
Can we do the afternoon, Judge? I am currently scheduled for 2 matters on the 10th at 8:30 in the morning, and I am trying to move one of them to later that morning. Could we do these on the afternoon of the 10th?
No, we don't have anything in the afternoon.
I'll try for 11:30 then, Judge.
Okay, April 10th at 11:30.
Okay, thank you.
Bond will be continued.
Thank you, Judge.
Thank you. My objections are noted for the record. Thank you. Have a good day, Judge. Mr. Mercedes. Okay.
I got a lawyer to come too late, so I got a gap.
I gotta go do my 10 o'clock.
And he's not gonna be here till 10:30, so if you all have something at 10. It is a dismissal. Okay. Mr. Epps.
Yes. Yeah, 10:30 is gonna be dismissal.
Ready?
Yes.
Ms. Jefferson, I'm sorry, she's got a gap, so take a copy.
Okay, sounds good.
Thank you.
Well, I have big gaps at times too. so-
Yeah, and that's what I was doing. All right, are you ready on Harper?
Yes, Your Honor.
Was this a tag team match or you? the judge?
Yeah, we're. Go ahead. Are you here on Harper?
Yeah.
No, Judge,
I'm-
I'm sorry, for Attorney Richardson on Zoom.
Yes.
Okay. All right, case number 220601760, people of the state of Michigan versus Leonard Harper. Defendant is charged as follows: count 1, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Appearances for the record.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850. On behalf of Mr. Harper. Mr. Harper is not present on Zoom. I have spoken to him previously. I'd asked to waive his presence for today.
All right, and how do you wish to proceed?
Judge Sabree set the second PCC to ensure that I received all the discovery. It does appear that it has been sent to me. It hasn't made it directly to me, but I know my office received it. So I believe we are prepared for exam. I think we already have an exam date as well.
You have a date?
I believe so.
April 12th? Yep, April 12th at 9:30.
Okay, thank you, Your Honor.
Yep, you're welcome. If there's no objection, court will continue the bond.
No objection.
Thank you, Your Honor.
All right, thank you. Parties on Goodnow. All right, case number 23055471101, people of the state of Michigan versus Jacob Goodnow. Charged as follows: explosives, manufacture, possession. A Molotov cocktail. And count 2, arson, preparation to burn real property. And count 3, explosive, manufacture, possession of Molotov cocktail. Did I pronounce that right?
Yes, sure.
All right, appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. For the record, James Schlock on behalf of Mr. Goodnow, 30720.
All right, and how do you wish to proceed?
We're ready to proceed with an exam. I would move to sequester witnesses.
All right, are you ready to proceed?
Yes, Your Honor, the APA who's handling this case is out in the
They need
hallway.
to come on in because I have like a very small window here.
I have the court officer already.
Yeah, all right, sir, you can have a seat. Is there anything, who else is here? No, he's got 2 cases.
He does, Your Honor.
210600551. I'm not gonna be able to do both of them.
I believe the people may not be ready on the narcotics case.
Okay, and in that case, he's charged with, count 1, controlled substance delivery, manufacture, cocaine, heroin. Count 2, controlled substance delivery, manufacture, cocaine, heroin, or another narcotic. He's being charged with a habitual offender 30 cents notice. Is that your case?
Yes, Your Honor.
Are you, your appearance, please?
Alexander Kirker on behalf of the people, P86282.
All right, are you ready to proceed?
At this time, the people are not, Your Honor. The necessary witnesses have failed to appear.
James Schlock on behalf of Mr. Goodnow, I would move to dismiss.
All right, thank you. Today being the date and time for the preliminary examination in this matter. The people are unable to proceed without the necessary witness or witnesses who were subpoenaed to be here. This matter will be dismissed as a dismissal without prejudice. Understand these charges could be brought back against you on this matter. All right, I need the APA on the other matter.
Your Honor, she said she's not ready on that one. She
All
said,
right.
put y'all do Johnson first. Okay.
If that's the case, Your Honor, if you wish to call it.
Yeah, but I'm probably not gonna be able to start this other exam, because I have one at 10:30. I have one at 10 and 10:30 in my case.
I have-
Past this one.
If I may, Judge, I have the Perez matter as well, and that's set for 10:30.
Well, it's not 10:30 yet, so
Oh,
you
okay.
can't proceed
I was
unless
gonna
they're
say-
ready on it. So, What's the other case is Johnson.
Yeah, that's a
Okay,
case, yes.
Okay, so, and that one, and the attorney, are you the attorney?
I'm Perez.
I'm looking for the attorney on Carlos Johnson. Are you the attorney on Johnson?
Yes, sir.
Okay, thank you. Case number 23055840001, people of the state of Virginia versus Carlos Johnson. Charged as follows. Count one, stolen property, receiving and concealing $20,000 or more. Count two, stolen property, receiving and concealing a motor vehicle. Count three, weapons, firearms, possession by felon. Count four, weapons, carrying concealed weapons. Five, police officer, assaulting, resisting, obstructing. Six, weapons, felony, firearms. 7, 8, 9, weapons, felony, firearms. Defendant is being charged as a habitual offender for defense notice appearances for the record.
Alexander Kirker on behalf of the people, P86282.
And good morning, may it please the honorable court, Sophia Curry, P 72103, appeared on behalf of Carlos Johnson.
All right. And are the people ready to proceed?
They are, Your Honor.
All right, and counsel, your client is not here.
He is not, Your Honor. I have had zero contact with Mr. Johnson except for at the PCC. The telephone number provided to me on the appointment sheet was his father's. I left a message.
So he appeared at the PCC.
He did appear at the PCC.
He received the date for today's date.
He did receive today's date. However, I sent him a letter because I had this in my calendar at 10:30. I sent him a letter on March 21st saying appear at 36th District Court at 10:30. But from the time of the PCC till now, the telephone number that he gave me at the PCC just goes to voicemail. I tried to leave him a message this morning, saying, hey.
So you think your client may show up at 10:30?
He may, but I'm willing to sit here and wait. If the court wants to enter the capias, I'll wait out here to 10:30.
Well,
walk him
if you
in.
gave your client another time than what was given in the court, then it wouldn't be fair for me to enter a capias until 10:30.
I just want the court to know I've had zero contact.
Okay, so we'll recall that at 10:30.
Thank you.
Okay, we'll give your client an opportunity to get here before 10:30. Okay.
Okay,
All right.
thank you.
All right, so there's no prosecutor, they're not ready on this one, and I'm afraid to get it started.
Oh, here's your comment.
Yeah, because I've got a problem. I'm already backed up in my courtroom. So, if you've got like cases or whatever, if I get a break or whatever, I'll surely come back over.
Okay, thank you.
at a later date, these charges could be reinstated against you. Do you understand that?
Yes, ma'am.
All right, did you have a tether or anything?
No, ma'am.
All right, matters dismissed.
Thank you. I am back for some paperwork. All right. And good luck.
All right, I've got go back, I've got my weapon. Wow. All right.
Thank you, Judge.
Okay, we have something else. I will.
Let's wait.
Okay.
You're not quite
All
ready.
right.
You guys are ready.
If it gets dismissed or anything and I can come back, I will.
Okay, thank you.
Yeah. All right, raise your right hand. There you go. And do you affirm the testimony you give to this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, you may be seated, sir. And just for the record, it is case number 2305547, for the state of Michigan versus Jacob Goodnow. The charges have previously been stated. Thank you, Your Honor. Sir, would you, I'm going to ask you a series of questions. That mic is movable. If it's easier for you, you can put it on your lap or where it's at.
Okay.
If I ask you anything you don't understand, please just stop me. I'm happy to rephrase. Could you kindly restate your name for the record, sir?
Emmanuel Taylor.
Sir, what do you do for a living?
I'm a Baptist pastor.
Sir, I want to take you back to the date of August 23rd, 2022. Do you recall that date, sir?
Yes, ma'am.
Were you at the location of 14770 Navarro Street in the city of Detroit, County of Wayne?
Yes, ma'am.
Could you tell the court what's at this location?
It's a residential home,
Whose home is it?
my home.
Okay, and who do you reside with at this home, at this location?
Me, my wife, and I have a little pet dog.
Okay. On the date that I just mentioned, who, if anyone, was with you at your home that evening?
Me, my wife, and my dog.
Sir, briefly, did something happen at this location on that date that brings you to court today, sir?
Yes, it did.
What is that?
My neighbor tried to fire my house.
Okay. Would you be able to identify that person that did that?
Yes, ma'am.
Is that person in the courtroom today, sir?
Yes, ma'am.
Could you please tell the court where the person is seated and an article of clothing that they are wearing?
Sitting right there with the black shirt on, white t-shirt on.
Your Honor, may the record reflect the identification of the defendant, Jacob Goodnow? All right, so noted. Thank you. Sir, briefly, how do you know the defendant?
Well, he's a neighbor. He's been in the neighborhood about a year or so. I met him, he used to come down to the house when they moved in and get water from me because they didn't have no water in the house.
That's when they first moved in?
Yes.
Okay, you say they, so he moved in with someone else?
He had a girlfriend and he had a little incident with his girlfriend.
Okay, so we're not gonna go into that incident with the girlfriend? Not a problem. Sir, let's start from the beginning on this day, on the date we mentioned on August 23rd. What if anything happened that evening that drew your attention, sir?
My wife was laying on the couch. I was laying in the bedroom watching TV. And I heard a boom. She heard a boom. And we don't know what it was. So we got up to look. We didn't see nothing.
Okay. So, even though you didn't see anything that evening, so when did you realize that something may have actually happened that evening of August 23rd?
Well, we got up the next morning. She had to go to work. So when she got up, she smelled something that didn't smell right.
What his wife perceived.
If you can focus on, you can indicate what you observed your wife doing, but if you could focus on your perception and what you observed that.
Well, I observed it too because I walked up to the door.
Okay, and what did you observe, sir?
I observed the smell. And I didn't know what it was, so I didn't pay it no mind. I went back in.
And what could you smell?
It smelled like kerosene.
Okay. Did you eventually inspect the outside of your home where this?
I got up later that morning and approximately around 8:30, 9 o'clock. And I opened up the door. I noticed there was broken glass all on my porch, kerosene all on my table, and I took the liberty to clean it up. And so I went to my cameras to see what happened.
So you said cameras. You have surveillance cameras at your home, sir?
Yes, ma'am, I do.
Okay. And did you discover anything on your cameras?
Not at that particular time.
Okay, when you say not at that particular time, did you look again?
Yes, I did.
What made you look at your surveillance footage again?
Well, later on, that day when I didn't notice anything, I was sitting out on my porch. And my neighbor, the defendant, happened to come to my house. And he made a statement. He said, "Did your house get firebombed?" I said, "What do you mean? Did my house get firebombed?"
Can I ask you, sir, and I'm sorry, I don't mean to cut you off, but I do want to ask you, did you tell that neighbor or any neighbors what you had discovered that morning?
No, ma'am, I just finished cleaning it up.
Okay, so, please continue. What other information did the defendant provide?
Okay, he came down and he asked me, "Did my house get firebombed?" And I said, "Yeah." "Well, how did you know?" And he said, "Well, they firebombed my house too." I said, "Well, why would they firebomb my house or your house? And I ain't done nothing to nobody, and I'm sure you ain't. You working on my house." So he said,
I'm sorry, sir, go ahead.
he said it was two black guys. I said, "Well, how did you know?" He said, "Because I seen them when they took off running." I said, "Well, what time was this?" He said it was around 11:20. So he left.
Okay, so based on this information, sir, that he provided you, okay, he indicated at 11:20.
Yes.
Okay. I do want to ask, you said you were on your porch.
Yes,
Did
ma'am.
you actually observe the defendant walk up to you before he gave you this information?
I seen him coming down the street.
Okay. Did you observe him by any chance going to any other neighbor's houses to ask these
He
questions?
went to nobody else's house. He come to my house, and when he left my house, he went back home.
So you didn't see him on his way home, stop at anyone else's house?
No, ma'am.
Okay, so after you obtained this information voluntarily from the defendant, you indicated that earlier that you went back and looked at your surveillance, is that correct?
Yes, it is, ma'am.
Okay, and once, what, the second time around, did you do differently when observing your surveillance cameras than the first time?
Well, I put in the time that he told me.
Okay.
And once I put in the time, sure enough, I happened to notice the defendant throwing a firebomb at my house.
So you watched the video and you actually saw the defendant throw the firebomb at your house?
Yes, ma'am.
Okay, so what did you do? And I'm gonna ask you more questions, but I'm just trying to speed this along. We'll get a little bit more into detail what you watched on the video, sir. What did you do after you observed the defendant? When you say firebomb, what do you mean by that?
Well, when I looked at the camera, you could see the defendant with the bottle in his hand, and if the red was lit, and he threw it at my house, and he took off running down the street.
So you say a bottle, so like a Molotov cocktail?
Molotov cocktail.
Okay, and it was lit, all right. So sir, what did you, after observing this video, what if anything did you do?
Well, after I looked at it, I noticed that the defendant was wearing the same shirt and the same pants. That led me to believe it was him, and I knew it was him by the way he was walking when he took off after he left. So I went down to his house.
Okay, and what, did you confront him when you went to his house?
Yes, I did.
Okay. Were you able to obtain any further information from the defendant when you confronted him about the video you had observed?
Well, he came out the house and he showed me a 2-liter bottle with kerosene in it.
At his house?
Yeah, right there on his porch. And then had the nerve to tell me that they left it on his porch. Why would they leave a bottle on your porch?
So when he was indicating they, he was indicating, who was he referencing to as they? You say they.
I didn't hear that.
Who was he referencing when you say they?
I guess he was talking about.
Okay, stop. Okay. Speculation. I don't want you to speculate. I just didn't know if he had told you any other information.
No.
Okay, so after you confronted him, what, did he confess? Did he give you any other information?
No, ma'am.
Okay. What did you do after confronting him, sir?
I left. My wife She didn't want to stay at the house, so she left and spent the night with her daughter. I left. My wife went to work from over there. She came home the next morning. She called the police department. I in turn called the fire marshal.
Did the police and or the fire marshal come to your home to investigate?
Police came first. I gave them the pictures of my video. I even let them come in and take it off my camera, my DVR. And they took the pictures. And I believe it was later on that day or the next day, the fire marshal came.
Did you provide them with the information of, what you just provided, the court, sir? Same information?
I sure did, and I also, gave the glass, the broken.
No question to the witness at this point.
All right, there isn't. Sir, what if anything did you provide the police when they came to your home?
Video, and I also gave the, fire marshal the broken glass.
So when you say you provided them the video, is this the video that you have testified, is to, the video that you observed the defendant, actually, throwing the Molotov, or as you, described it, firebombing your home?
Where's the video?
No, I'm saying is the video you provided them, is that the video you provided them?
Yes.
Sir. Runner, just, 1 second, I'm pulling up the video now.
All right, and so you're going to bring it over to him as opposed to?
Yes, Your Honor, just for efficiency, so that because we have been having issues with the screen up top.
Okay.
And I will, not to waste the court's time, I will fast forward the video to just a few seconds prior to the relevant parts of the video.
Right, what's the problem?
I'm sorry, Your Honor?
The defendant will have a right to look at that video. Has your client seen that video?
No, Your Honor.
You need to log in. You're gonna need to log in and share it.
Is it going to be on the screen or are we bringing it up to the
We've
judge?
been trying to get it up on the screen prior
Okay,
to
so
you
this
coming
is
in.
what we'll have to do. You can show it to the witness and then I'll have to have you show it to your client.
Okay.
We'll do it that way.
And I am fast forwarding, Your Honor, so it's not longer than a
Well,
minute.
if you can, whatever you believe is relevant for the court.
Thank you, Your Honor.
Now, if he wants to show something else, then he can.
Your Honor, did you want me to, and I apologize, you indicated I can proceed with the witness with the video, or would you like us to show the defense counsel the defendant?
Show the witness the video, and then whatever you show the witness, that has to be shown to the defendant.
Your Honor, people would, let's say, people's proposed exhibit 1, indicates home surveillance video from the date, question the 23rd. And may we approach, Your Honor? Thank you. I just want to make sure I have the right time. So I don't waste the court's. Your Honor, the video starts at 2 minutes 49 seconds, which is actually technically the time and date stamp is 23 hours and 20 minutes and 9 seconds, technically 11 p.m., 11:20 p.m. on the 23rd. Mr. Taylor, before I start this video, could you please describe what we are looking at here in the video?
You're looking at the front of my house.
Okay. Is this? Is there any sound in this video, sir?
No, ma'am.
I appreciate it. Thank you. sir. Hit pause here, and I am pausing it at 23 hours, 20 minutes and 25 seconds. And technically on evidence.com, that's the 3-minute and 5-second mark. Sir, can you please describe to the court who you see in this video at this time?
The defendant.
Okay. And I know you mentioned it earlier, but how certain are you that this is actually the defendant?
I'm very certain he had the same shirt on, same pants, and same boots on the next day.
When he came to your home to
When he
inquire
came.
about fire bond?
Yes, ma'am.
Okay. And
I see him every day, so I know how he look and how he walk.
at that moment, can you describe it for, where exactly did you see the defendant throw what you testified to earlier as a Molotov cocktail?
He threw it over by the hedges there. And I'm assuming it hit the window right here.
And when you say you're assuming, is this based on the items that you cleaned?
Yes, the glass, if you notice, it's a table right here. This is where the glass and the kerosene was at, all on that table. And broken pieces of up here.
Your Honor, maybe show this to the defendant. Thank you.
All right, counsel, is there anything else?
Just to clarify, how is it that you're so certain that that's the defendant?
I see him every day. I know the way he walk. He's only 7 in the neighborhood. And I know all my neighbors. When I saw the video, I knew right then and there it was him.
And last question, sir. After watching this video and discovering what had occurred, what, if anything, have you done since in reaction to this incident?
I've been up practically every night
I'm sorry,
watching.
stop, there's an objection, so let me.
Relevant.
All right, what is the relevance?
Your Honor, the relevance, I'm trying to show, if you allow him to answer.
It still has to be relevant.
I know.
You have to state why it is relevant, that's the objection.
Your Honor, I'm trying to show the effect that the incident did have on the complaining witness. As you can see, obviously we have, I believe, probable cause on the part, but also at count 1, I don't want to go ahead and put anything. I'd rather explain it after he answered, but since I am being asked, one of the elements is and/or put the victim, frighten them, intimidate them.
All right, thank you.
Thank you, Your Honor.
That's appropriate. All right, so overruled.
Could you answer what, if anything, you did after this incident?
It left me and my wife in fear. And the reason why, because we have to sit up every night and look at my camera, not knowing if he was gonna do it again. And that really bothered me.
I understand, sir. Thank you so much. No further questions.
All right, Franz and then counsel, I may have to interrupt you because they do have a matter ready for me to do. So, but I will let you get started.
Let me real simple, no question.
Okay, no questions. All right, the witness is excused.
Thank you.
Thank you.
All right, are the people calling additional witnesses?
No, Your Honor.
Is the defense calling witnesses?
No.
Is there a motion?
Yes, Your Honor. The people move the defendant Jacob Goodnow be bound over on count 1 explosives manufacturing possession of Molotov cocktail explosive or incendiary device causing property damage. Count 2 arson preparation to burn real property. And count 3 explosives manufacturing possession of a Molotov cocktail. I would reserve argument at this time. Thank you.
I would oppose the bind over, Your Honor. The people are primarily relying on the video that court was shown. And when the court saw the video, there was nothing but a figure, somebody walking up the street and throwing something. There was nothing in the video that showed anything about this person's face or anything else that would establish some type of identity, including tattoos and other descriptive things about a person. We just have somebody throwing something. And he also claims that my client represented that something similar happened to him that night. And I believe that based on what was going on the complainants, the witnesses' porch, seeing him clean up and all that, everything like that, it would be easy for one to conclude that there was a problem at that house too. So my client claimed to have been a victim as well. He saw the complainant cleaning up. I think that he was just asking an innocent question. There seems to be nothing in the way of a motive to do anything along these lines. We have nothing from the police department to identify any substances, any fumes, anything about the glass, the broken glass that might be in relationship to it. So for all those reasons, Your Honor, I would ask the court to dismiss each and every one of these charges.
All right, counsel.
Thank you, Your Honor. I respectfully disagree with defense counsel. As the witness indicated, as far as identification, this is someone who has seen this person on a daily instance. For the last year, it is his neighbor. He can identify him. Maybe to us, we at first glance, it is not obvious to us because we do not know the defendant like this witness does. This witness at no time while testifying or at any time in any police indication doubted or questioned who it could have been. He has been confident indicating it was the defendant. When asked why he is confident, he also indicated that that he is familiar with how the defendant walks, his figure, because he walks by his house every day. He also, or on daily, he also indicated that the defendant, when he came up to him to speak about firebombing, was wearing the exact same clothes that he is seen in the video wearing. As other circumstantial, when the complainant went over to the defendant's home, the defendant had kerosene sitting on his porch or in his possession when he went to his house right outside. So regardless of the reasoning, I'm sorry, Your Honor?
Wrap it up.
Okay, regardless of the reasoning the defendant gave, at this point, we believe probable cause has been met. We did watch the video. The defendant was positively identified. The video does show clearly it was a Molotov cocktail that was lit. It was thrown at the the complainant's home, therefore covering the intent to damage or destroy real property. On top of that, he also put them into fear. Count 2, he attempted to burn the real property. In count 3, just him holding that Molotov cocktail, being possession of it, gives probable cause, as indicated.
All right, thank you, counsel.
Probable
All
cause
right,
has
the
been
court
met.
has an
Thank you.
opportunity to hear the testimony in this matter from Mr. Emmanuel Taylor, who resides at a location on Navarro Street in the city of Detroit. States that on the date and time in question, August 23rd, 2022, while at home with his wife and his dog, he stated that he heard a big boom, got up, didn't see anything. The next morning, he stated that he could smell kerosene. He opened up the door, observed broken glass on the porch. He also observed kerosene on the table. Then he went to his cameras to see whether or not anything had occurred. He stated initially he did not. He stated later that day that the defendant came to his house while he was, I believe, sitting outside. And he stated that the defendant asked him if this house got firebombed. And he told him yes, and apparently the defendant stated that his house had gotten firearms as well. And stated that it was two black guys, and that it happened around 11:20. Well, then the witness states he went back to his camera to the time that the defendant had stated. And when he went back, he saw an individual who he has identified as the defendant throwing that device that was lit at his home. He also stated that he believed it was the defendant because the defendant was wearing the same shirt when he came to his home, inquiring about his house being firebombed as in the video. He then, after viewing this, he went down to the defendant's house and inquired about the incident, and then he said the defendant indicated that, showed him a bottle saying that they had left it. And what's interesting is that the defendant tells him that it was two black guys, but clearly in the video it's one person, and it does not appear to be anybody black. And so this witness states that he observes, he sees the defendant all the time, knows how he walks. And while the court would admit that I can't tell who that is in the video because it is not clear, we have a witness who is more familiar with the defendant, and also the other circumstances that were brought out. The fact that the defendant tells him that he saw who did it, when we see who did it, it's not two people, it's one person. And that's what the court saw. So there's enough evidence to show probable cause here. People haven't at their burden. The court finds there's probable cause that the crime was committed in the city of Detroit, and probable cause to charge the defendant in all three counts contained in the complaint. The matter will move forward to Wayne County Circuit Court. Arraignment on the information is
April 13th at 9 a.m.
April 13th at 9 o'clock.
Very good.
There's no objection. The court will continue to bond with the instructions that the defendant may not have any contact whatsoever with the complaining witness.
I don't believe it's in the neighborhood anymore.
All right, well, that's good thing. Thank you. All right.
I'll be
All
on
right.
Monday.
I am done here.
It's just one case, I think.
Yeah, hurry up. You can call the case petition.
Also have your signature on one for this one. Okay, this on here. Oh, thank you. Thank
Okay.
Calling case number 2355600. The people of the state of Michigan versus Andrew Borgowski. The defendant is charged with count 1, controlled substance possession of cocaine, heroin, or another narcotic less than 25 grams. The defendant is an habitual offender for offense notice.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Andrew Majo, P45619, on behalf of Andrew Borgowski, who was not appeared.
All right, and assuming that you gave your client notice of this exam date, either by telephone or by letter?
Yeah, I was a regular contact with him. I have no explanation why he's not here.
All right, people wish to be heard.
Your Honor, based on this information, we would ask for a move for habeas.
All right, at this time, the court will issue a habeas. That personal bond is revoked. The bond is set at $5,000 cash for surety. All right, thank you, counsel.
Thank you.
Thank you.
Right. Right. A little later.
Right.
Okay, thanks.
Have a good day.